country of. It's the evil and the ugliness of people's hearts these days is everywhere.
This is Franky Rose's Think Tank. Here's your host, Franky Rose.
Hey guys, welcome back to the Think Tank. So we are just waiting for court to start. They're on their lunch break right now. And see where this leads. I personally, if she's been known to self-harm in the fairly recent past, that is a concern. Medications are a little bit of a concern for me because unless she's in a spot where they can monitor quite often, like, I don't know, some kind of halfway house, I don't know, but someplace where she can be monitored closely as she adjusts. But they haven't really convinced me that she would be safe. Maybe she needs to be moved to a different type of facility and then get acclimated that way. So, yeah. Oh, good to see a collector, Pam Dandy. So we are just waiting for the courthouse. They're showing us their emblem and their flag. Hello, Mel. Ruth, good to see you guys. Welcome back. Welcome back. I'm just kind of looking at earlier. Oh, lordy, lordy. Are you telling me that, okay, collector, are you telling me that business is eating shite? I find that very odd. I hope just eating badly. I'm not going to read into that. Yeah, I'd like to get into that woman's brain for about. Oh, you guys had a good chit chat. That's good. Yes, a cannibal. It is very interesting. Miley Cyrus. Sorry, guys. I'm not off in Lululand here. I'm just kind of going over chat. I'm just not wanting to put some stuff up right at this point. Hello, 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 hello. Hello, hello, hello. Hello, hello. Where do I find these cases? A lot of them are actually suggested to me. The mods like to send stuff to me, or we've got general chat that's in Discord, and I'll go through that and see if there's anything that catches my eye that I think you guys might be interested in. But a lot of it is suggested to me. I do like to get everybody's input as to what they're interested in. So yeah, a few different ways. That's a concern. I might want to put that one up. I believe she needs to work out her diagnosis. She's denying schizophrenia, which is what she has. She denies it because she doesn't want the same diagnosis as him. She's really messing things up. Oh, I get it. That's kind of what I'm thinking. And I don't know her. Okay. Hello, Tony. Okay, who's eating caca? Things you find in chat. But hey, it's damn interesting. I'm sorry. We all have the same interests here, which is, yeah, collector does. Yeah. Yeah, he does. I'm enjoying his input as far as this goes. I'm putting up a Tigger warning. I love that Dandelion with the Tigger warning. Tony's in the house. Doritos popcorn. Who's eating the guano? I can't figure it out. I can agree with that, collector. She needs to focus on herself. Yeah, I wasn't interested in it, to be honest, Chopper. Do you think so? I'm not sure about that, Tony. I'm not sure. I think the one girl just might be, and I mean, we're talking about Morgan. I think she's got some issues that she needs to work out. Hola! Hey, JJ. Chad's lawyer is acting all peeved. Yeah, but not I don't know. I'm not necessarily gonna agree with that. I'm not. I mean, I imagine you're the same as me. I've met quite a few people with schizophrenia, and treated properly, they're good. But the problem is they tend to stop taking their meds after a while. But at the age of 12, it could just be starting. That's things are changing in a person, especially a girl, in their bodies. Aw. But with schizophrenia, a person can be fine and then not fine. She doesn't seem ready to me. She needs, by what I'm seeing anyways and reading, it seems that, she just needs to get some more medical help and possibly understand her diagnosis as well as her crime. She did. Yeah, she did unalive someone, Mel. From the age of 2 to 10, usually that's when you will start finding split personality disorders or even schizophrenia. I mean, guys, 14, 18, somewhere in there. Did she survive? Oh, okay. I didn't realize that. Yeah, they did, but that's still it doesn't mean that one of them was, firing in all cylinders, right? Yep, 12 to 18. Oh, wow. She survived. That's good. And a nurse. Oh, developing. Yes. That is the thing. It's overplayed. So when there's somebody that is truly mentally ill, everybody's got doubts, right? It's like crying wolf. Yeah. Yeah. I mean, all you have to do is kind of look at the thumbnail for this. That doesn't look like a mentally stable individual to me. Yes, you can. Yep. A lot of times not, though, right? How many times has the really good guy turned into like one of the worst predators? Oh, that's it. I was shocked. I was shocked. I mean, even watch her through trial, it was like, oh. And when I found out that she was not considered mentally ill, I was like, what the actual F? Out of anybody well, there's a few cases where you know that they're not working properly and they'll go, uh-uh. It's like, come on. Too many people have played that card. But the courts need to figure out the difference and learn the difference. Hey, Christy. Good to see you. Good. Good. What do you do for work, Collector? What do you do for work? I'm curious. No, he was fine. Not mentally ill. I don't think Dahmer was mentally ill. Not by the legal term, the legal jargon. Yeah, mad or bad. That's right. Always an interesting question. Absolutely. Weren't they supposed to start at 1 Mountain Standard? Ed Kemper. Good example, right? I think I can't say. I'm just going to put that up. I was once a correctional officer for the Milwaukee County Sheriff's Department for 11 years. I'm technically retired through them, but I'm physically disabled from autoimmune diseases. I'm sorry for that. To me, anybody that deletes someone has something wrong with them unless it's clearly self-defense. Do you know what? But the legal term for the legal term does not break down to how do I say that? To be diagnosed legally, for insanity, it takes a lot of different things, right? It's not just the act when you're dealing with the legal definition. Like, we might see that something happens and go, whoa, that's crazy. Like, look at what we just watched with, split personalities, etc. When the Apple River, that guy wasn't insane. And look what he did. He wasn't insane. Taylor's your business? Yeah. Come on. But let's do that. In Florida, remember, guys, how come Arlene Warnos? Arlene Warnos, is that right? Tell me she wasn't legally insane. All you have to do, Eileen Warnos. What is wrong with my brain? I mean, she was put down. And you can't tell me that Warnos wasn't crazy AF. Like, she was seeing things in the roof and picking it, like Eileen Warnos. Yeah. Do you have a letter from Aileen? Can you photocopy that and message it to me? That is so awesome. If you don't mind, I mean, I don't know. Is that a pushy question? But that intrigues me lots. Are you serious? Thank you. Thank you very much. Wow. Really? Oh my God, I appreciate that. There is. From the English guy, right? He does a couple really good documentaries. 1 minute and it'll be in your email. You so rock. So how do you end up contacting? Is this like an interest just basically as far as psychological goes? No, I thought they were moving a little bit in court. Oh, Chopper. Wait. Wait. Yeah, she did with a bread knife. She did it with a bread knife, Chopper. And put it in a bucket. But when she left, she wanted to take that home with her. And forgot it. Yep. She was totally insane. I agree with that. But if the law says you can't put down insane people for their acts. If that's what the law says, then that's what the law says. And she was, you know, YouTube's acting up. It is. I know, I'm kind of an eye for an eye girl too, but, when it comes to, like, true insanity, and I'm talking true insanity, like One Flew Over the Cuckoo's Nest type insanity, that group, come on. Oh, yeah, same thing. Yeah, I covered Taylor Business for a long time. Deep dives. She interests me. She does interest me. You know her case from front to back. Yeah. Yeah. No, I find her very, very interesting. I do. La 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 dun, 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 dun. They don't interest you? Yes, there's not a lot of them. And when they do it, they tend to do it graphically. It's either a bad liquid dropped into things, but if there's a little bit of this going on, they can do anything. And I truly believe Taylor Business is like cuckoo. I do. Yeah, super interesting. But, I've got an interest in all of these cases because I really wanna know how the noodle's functioning. It it intrigues me how the mind works. You can do this, and yet you're this. You can look like the straightest board ever, but meanwhile, you're over here doing all of this stuff. Or you got things that are right in your face, and you either choose to see it or you don't, right? Yeah, she's evil. Yep, I can't deny that. Yeah, right, James? For sure. For sure. It's like James said a little bit ago. Everybody tries to use that defense. Daryl Brooks, there's another example. He's not crazy. He's effed up. Absolutely. But he's not crazy. Yeah, he's not crazy. He knows what he did. Taylor Business and Sarah Boone. Yeah. Yeah, it's just, oh my word. Oh my word. Yeah, the mind intrigues me. It does. How can someone be one thing over here, but in reality they're this monster? And sometimes you don't even get a clue. Have you got letters from Boone? Now that's interesting. That's interesting. Oh, okay. Throw it up in Discord. Marie the Russian hit woman defense. Let me know when you put it in there, job. Yeah, well, that's amazing. That's absolutely amazing. With Boone? 3 letters, and it was like, yeah. She's an interesting. Yeah, yeah. Actually, in the playlist, we watched her interrogation, and oh la. Yeah, she said, "Hold on, I've got something for you." Ian Huntley. Yep, not crazy. Yes, entitled, entitled. And how the hell does that work? I mean, you knew how entitled she was right from the get-go, and it's just like, I couldn't deal with her. What is she on? Lawyer 8? Or did she just is she waiting for, like, lawyer 9? Okay, guys, here we go.
We back on the record in State versus Geyser, same case number and same appearances. We completed testimony this morning, and now the court's in a position to hear closing argument from the attorneys. So I'll proceed then and call on the state. Attorney Zubakowicz.
Thank you, Judge. Judge, I'm going to start first by looking at the statute. As Morgan filed her petition for conditional release, at that point, the court had to grant it. That's the way the law is designed in this case. And you are mandated to grant it unless you find clear and convincing evidence that she poses a significant risk of bodily harm to herself or to others. I think the evidence here is clear and convincing that there is such significant risk. This isn't beyond a reasonable doubt. This isn't even by a preponderance, Judge. It's by clear and convincing evidence. And again, I think that clear and convincing evidence does exist here in this record by way of the reports from Dr. Collins and Dr. Lundbaum. You have two of, I guess, what I would call the leading experts in the state on issues of competency, mental responsibility, and conditional release that have devoted their careers to the area of forensic psychology. Dr. Collins, I believe, testified she's done thousands of competency evaluations, thousands of mental responsibility evaluations, and at least hundreds of reports regarding suitability for conditional release. I think their experience in this area is extensive, and their opinions present clear and convincing evidence. Each of them also, Judge, has a great deal of experience with Morgan Geyser. Dr. Collins, presumably because of her expertise, was hired by the defense in this case. Right after the offense happened, she was hired and I believe met with Morgan for the first time sometime around June 4th or 5th, 5 days after the offense actually happened. She knows Morgan better than any of the doctors that have testified. She's had a longer period of time with her. She knew her back then, immediately after the offense occurred, and has had the most contact with her throughout the course of the almost 10 years. Both of these doctors, Judge, drafted lengthy reports that were thorough and detailed. I guess I can't really say that quantity equals quality, but I think when you look at the reports of Lundbaum and Collins, certainly the quantity shows the amount of effort and detail that they've put into writing their reports and that they put into arriving at their conclusions. Certainly, in my opinion, much more so than Dr. Robbins. His report is 6 pages long. It doesn't have the same detail. It doesn't have the same thoroughness. It doesn't have the same recitation of what's gone on at Winnebago with Morgan in terms of treatment and therapy. Their reports, Judge, I submit, are better. They're more well done. And I think the fact that they are that gives them better quality than the report, and ultimately a better conclusion than is arrived at by Dr. Robbins. I know just today while on the stand, I thought the testimony of Dr. Lundbaum regarding her description of the different paths that this case can take was very informative. I think it showed that she didn't start out, Judge, with, I'm going to find a way to keep Morgan Geyser in. She looked at everything and assessed everything, and that took her to the conclusion that she arrived at. Both recognize the improvement that Morgan has made and admit that release will happen, but she's just not there yet. Dr. Collins opined that 6 months to a year was needed to satisfy her that the risk was no longer significant. Both of those doctors included, Judge, the legal standard in their reports. That wasn't anywhere in the report of Dr. Robbins, and I think his view on it, at least in my opinion, was somewhat incorrect in terms of the law. He felt that he could balance what was in Morgan's best interest against any potential risk. And if the benefit was greater to Morgan than the risk was to the community, well, that meant she should be released. That's not the legal standard, Judge. There's nothing in 971.17 sub 4 sub D that talks about the court looking to the best interest of the person who is under institutional care. It says simply that the court shall grant it unless there's clear and convincing evidence of a significant risk. I don't even necessarily think that, I know the opinion of Dr. Pope, which I guess maybe I should have looked into it more, Judge, but I felt kind of blindsided by it. I had not spoken to Dr. Pope. I didn't know that she was going to be testifying. I didn't, we don't have any report from her. I don't have a CV. I don't necessarily know much more than she's been with Morgan for 5 years. But in any event, she seemed to opine that Morgan needed more experiences within the community, that based on her age, it was time that she start receiving those, that would be in her best interest. But again, that doesn't speak to whether or not there's a significant risk. I know she did say that she didn't feel there was a risk, and she was more aligned with Dr. Robbins, but again, without having a full report from her and knowing the entire basis for her opinion, I don't think the court should give that opinion as much weight as Dr. Collins and Dr. Lundbaum deserve. Dr. Robbins, he had it wrong in his report. He said that this was Morgan's second time petitioning for conditional release. Well, we all know it's in fact the third time. I don't know why he waited until today to review the report of Dr. Collins. That was filed on March 5th before the report of Dr. Lundbaum, but in his report, it only mentioned reviewing Dr. Collins's August report. In any event, Judge, what I think I have the biggest issue with that Dr. Robbins included in his report was on page 4, where he indicates that the case is tragic, and he indicates that this is a particularly tragic story with many victims. No, there are not many victims here, Judge. There's one victim. There's one victim who almost died, and that was the victim in this case. There's one victim in 2014 CF 596. He states, including, of course, PL, but also including Morgan. I don't accept that, Judge. Morgan is not a victim in this case. If Morgan was a victim of her father, yes, that is also tragic. But the only information we have about that comes from Morgan. The information we know about our victim is that she was stabbed 19 times and left in the woods to die by Morgan and Anissa Wire. We know that she was found by a citizen witness because she cried for help. Help me, I've been stabbed. We know emergency personnel came to the scene, found her covered in blood. We know she was taken for medical treatment. Doctors opined that she was within 1 millimeter of losing her life. She had significant injuries to her liver, pancreas, and stomach, all of which had been stabbed. Her heart was struck by the knife. One victim in this case, Judge, and that was her. And she'll be a victim in this case for the rest of her life. She will have significant scars that she carries with her for the rest of her life as a result of what Morgan Geyser did. I would be remiss, Judge. I think Marcy's law requires me to let the court know that the victim's family is vehemently opposed to the release of Morgan Geyser. I know they indicated they did not wish to make a statement, but certainly wanted me to convey that to the court. So is there significant risk here? Well, Judge, Morgan Geyser tried to kill the victim in this case, and then 7 years later, she tried to kill herself. That was less than 3 years ago. I think that alone shows there's risk here, and the fact that it's a significant risk is supported by the doctors in this case. One of the other things that Dr. Lundbaum testified to today was, well, I guess I should go back. I touched briefly, Judge, it's not clear if Morgan was a victim of her father. The only evidence we have comes from her. We have another issue that was brought up by her about, well, was she faking all these years? The doctors say no, but I guess the question then becomes is, why is she saying that now? We don't know. That's not clear. We don't have a clear answer on that. We don't have a clear answer, Judge, on why she committed this offense. For years, the thought was, well, she's suffering from schizophrenia. She believed Slender Man was real. She believed Slender Man was going to harm her and her family. And she felt that she had to do this to appease him. Now we're getting a different version. We're hearing, well, she believed in Slender Man, but she wanted a way out of her family situation. So the motivation here is no longer even clear. Dr. Lundbaum testified today on some of those points, and I think the question became, and I know it was a question for both of the doctors, is can Morgan be trusted to report her symptoms? Dr. Lundbaum testified that this raises serious concerns. Not her only concern, but certainly serious concerns. Her reliability of her self-reporting is hard to know. That makes her a significant risk. Dr. Lundbaum questioned, is she motivated to reliably self-report? Is she willing to self-report? Or is she not going to because she wants to be released and to stay released? That makes her a significant risk. I would direct you, Judge, to page 33, at the top of that page on Dr. Collins's report, and page 30 of Dr. Lundbaum's report. Those are their conclusions and their arguments, Judge, as to why there is significant release here and why they cannot support release at this time. So the state is asking that you follow the recommendations of those two doctors and not allow Morgan to be released at this time.
All right, thank you. Then I'll turn to Attorney Cotton.
Thank you, Judge. As the state notes, the statute states as follows. The court shall grant the petition, shall grant Ms. Geyser's petition, unless the state proves by clear and convincing evidence that Morgan would pose a significant risk of danger or great bodily harm to herself or others, or serious property damage. Clear and convincing evidence. That means that the evidence is highly and substantially more likely to be true than untrue. Colorado versus New Mexico, 1984 Supreme Court case. The court obviously knows that standard from its years on the bench. But that's the burden. It's a high burden for the state to meet to prove that this petition should be rejected. And let's be clear, just so we're framing this appropriately, exactly what we're talking about, with all due respect, Your Honor. We're talking about this court approving the petition so that Winnebago can continue the plan for Ms. Geyser's release. She does not go anywhere today other than back to Winnebago, where she will remain at the mental health hospital for 60, 90, 120, however many days it takes or extensions they need for the hospital, for Winnebago, to come up with the release plan and submit it to this court. You are the gatekeeper. And if you grant this petition today, it doesn't result in Ms. Geyser simply walking out of the doors and going into the community. And even once this court grants the petition, even when that happens, she will have 30 more years of supervised release over her head. This is she served a significant period of time, but there's a significant period of monitoring that will take place after that. So nobody's talking about releasing Morgan today. And I'm sorry that the state feels blindsided with the court's decision to call Dr. Pope. Certainly we had no more advance notice than they did, but I thought it was a good decision. And what was significant about the Dr. Pope and Dr. Robbins, what's particularly significant about those two doctors, is both of them respectively have been either are the medical director of one of our two mental health hospitals or are a former director of Wisconsin's mental health hospitals. Dr. Robbins was the medical director of Mendota for a decade. In that capacity, I don't know if it seems to be that the state is suggesting there's maybe a lack of quality with Dr. Robbins. The credentials he brings to the table are frankly as high as any person you could ever call in a courtroom to offer an opinion about something like this, because he's spent his whole career working with mental health patients. He ran Mendota. He was in charge of all the doctors who drafted release plans and worked on release plans. And then Dr. Kayla Pope currently runs the Winnebago Mental Health Facility. And so when I hear the state suggest that it's just Dr. Collins who has significant experience with Morgan. That's not true. Dr. Robbins was involved in this case right out of the gate, just like Dr. Collins. Look at the case history reflects his involvement right away. So he has just as much historical years with Ms. Geyser as Dr. Collins does. And what's significant is that while Dr. Robbins supports release right now, the two reports aren't that far apart if we're looking at them closely. Dr. Collins does say today, this moment, Morgan should not be released in her opinion. But she offers the opinion that it should happen in the coming months. That's the language she used in her report. And whether that's 3 months or 6 months or however many months it is, by giving the green light today for Winnebago to begin the transition process, that's consistent with Dr. Collins' recommendation, that's consistent with Dr. Robbins' recommendation, and it's consistent with what Dr. Pope said. In fact, the only doctor really truly coming up here maintaining total opposition is Dr. Lundbaum, one of the four. And I don't know that we weighed up the number of this versus that, but Mr. Sapakowicz is talking about Dr. Collins having all this experience with Ms. Geyser, and that's true. She has met her on a number of occasions, and she's been involved, and we've had her involved. Dr. Pope testified today that for the last 5 years, she's been involved with Ms. Geyser. 5 years straight in the mental health facility at Winnebago. That's how long she's been involved. And what she said, Judge, is that she's known Morgan since July of 2019. And I think that Your Honor had said, so that's a long-term history with her, or she had said that's a long-term history. And then she said, Morgan, and this is consistent really with every doctor, Morgan has received the highest level of services available at Winnebago. Quote, she has optimized all that is available. We have very little opportunity to provide socialization to her. And she heard all of the testimony from each doctor. She listened to it for 2 days. And she told this court that she agrees with the conclusions of Dr. Robbins more than the other two doctors. This is the director of the facility that Ms. Geyser is currently housed at. She is telling the court, as both a treating clinician, as a director of the facility, and in her capacity as an expert for this court, quote, I think at this point, she is safe to return. There is not much more we can do to make her safer. A group home? She agrees with that. I agree more with Dr. Robbins than the other two doctors, and the critical period for development is closing rapidly, as Dr. Robbins also acknowledged. And I don't think anybody here is harboring under, especially not the former director of Mendota, nobody's harboring under any delusion over what the statute calls for and what we're here to talk about. Everybody has talked about their perception of Ms. Geyser's needs, but what makes Dr. Robbins and Dr. Pope so significant is because both of them have substantial history with Ms. Geyser, and Dr. Pope has probably the most ongoing, contemporaneous, daily contact with Morgan to assess how she is. Is she safe? Is she dangerous? Is she somebody that can be treated in the community? And you had a resounding testimony from Dr. Pope today that it's appropriate to begin this process. And what she testified to, Your Honor, is that there'll be a 60-day period of time. And you know this because you listened to the testimony closely, but there's already a transition team that's been assembled. Winnebago is waiting for essentially the green light from this court to permit the next step to occur. And we're talking about a small step. We're talking about Ms. Geyser meeting with her transition team and the transition team presenting a plan to this court that probably will involve her going to a group home or some sort of inpatient treatment plan like we proposed in our release plan that we submitted to the court. That's what we're talking about. But we're also talking about making sure that somebody who was found NGI after 10 years, now she's paid dearly. After 10 years, she's ready. And she wasn't ready previously. That's why the petitions were withdrawn, that she's ready now. And that plan that comes to the court, you may or may not approve it. You may not like the group home they suggest. You may think it needs GPS monitoring if that's not in there. And the court will have whatever input the court has over that plan. But Dr. Pope, the director of Winnebago, who's working with Ms. Geyser for the last 5 years straight, the most experience with her, and the person that entrusted to run the facility, is recommending that that happen. Along with Dr. Robbins, who's so well respected that he used to run the only other mental hospital that we have in Wisconsin. So really they're the two very top people. And I agree that Dr. Collins is a very top doctor too. I know Your Honor thinks highly of her. We do. That's why we've retained her on the case. And I think she's very close with to what these other doctors are recommending. And frankly, if there's any deterioration by Ms. Geyser, the first thing that's going to happen is that the release plan that's being proposed won't be proposed. They won't suggest that she be released. So this process will be contingent on, without a doubt, Ms. Geyser continuing on this positive track that she has been on for years, continuing to take medication, continuing to participate in therapy, continuing to remain a good patient at the facility. And if that happens, and if the court approves the plan, then some number of months down the road, just like Dr. Collins says, some number of months down the road, Ms. Geyser will go to a group home probably, or inpatient somewhere. There is no way the state met this burden of with at a minimum, two of the doctors saying, sign off on the petition right now, and another doctor, Dr. Collins, sort of there, but maybe some more months, and one doctor opposed. They didn't meet their burden of showing the court that it's highly and substantially more likely to be true rather than untrue that Ms. Geyser that this petition should be denied. And they have to overcome the presumption that it shall be granted. That's what the law tells you to do. It shall be granted. I think it's true that the window is closing. I think that as you have a very long history with Ms. Geyser. You saw her. You were the first judge on this case, and you've been the only judge involved in this case. And we've all watched her grow from a 12-year-old child into a young 22-year-old woman. And socialization is important because she's going to be monitored for many, many decades to come. And it's important that once we've maximized the services she can receive at Winnebago, and once she's proven that she is not harmful to herself and has never been harmful ever throughout her stay towards any other person, it's an isolated event that we have in this case, and it's horrible, one that she accepted responsibility for. And she has incredible empathy, as the doctors have testified to. But the time is right for the services that can no longer be provided at Winnebago, as their director told you, for those services to now be provided in a somewhat less restrictive environment. And for those reasons, I'm asking you to grant the petition.
All right, thank you. I appreciate your comments. Attorney Zepakowitz, any rebuttal argument?
I don't, Judge, no. Thank you.
No. All right, thank you. Thank you for the good arguments.
So you guys don't have to agree with me, but I think she's mentally ill. And with that said, my personal opinion is I think she needs to be locked up still. I don't think she should get out. And I don't think that she's doing what a lot of schizophrenics do. They pull out their hair. It's what they do. I don't know why,
One
but it's
aspect
common.
of the case, I think the court's in a position to rule, and I'll rule this afternoon with regard to the petition for supervised release. As was with the doctors that testified, the court's been involved with this case since the beginning. And as is Mr. Zepakowitz, and as has Mr. Cotton. So the history, the anecdotal history of the case goes back for the length of the legal proceedings on all sides and in all facets. The just an initial comment. The court asked Dr. Pope to be available from the beginnings in the event it was necessary that she testify. The issue of what happens at Winnebago for Ms. Geyser at this stage of her tenure there has been in the case. Everybody talked about it, that there's no place else to go, there's nothing else out there. I thought it was necessary that somebody from Winnebago be here to tell us what it really is, so we know what the status is. That's why I asked her to be present, and she didn't repeat, but she said what other doctors had said, that basically there isn't any place else from a remedial standpoint, not much else for Ms. Geyser to do. However, I forget which doctor it was. It may have been Dr. Collins or Dr. Lundbone, did state that what happens in a situation if Ms. Geyser stays at Winnebago is that they reemphasize the therapy that she has and they work more diligently at it. So it's not totally an end of the line type situation. Parties should also keep in mind that it gets lost in the shuffle, is that the court doesn't have to accept any professional opinion. It's clear that the court can listen to what takes place, but the court doesn't have to accept their final opinions. I look to the key case, not the key, well, it is a key case. There's a series of cases in Wisconsin involving Randall State versus Randall. Allen, Aiden, Randall. The most recent decision of the case is at 2011 WISAP 102. It's a 2011 decision, but Randall's been around since the mid-70s, 1975, 76. He murdered, the bottom line is he murdered 2 police officers in a really vicious way in the course of a robbery, and ultimately was committed and went through a number of petitions for review. And I think at least in the 2011 case that's been cited, it was his 4th petition for review. There, all of the doctors testified, and the 3 doctors testified in favor of supervised release. The court denied it. So that emphasizes the point that the issue of experts testifying still doesn't change the court's view that the court makes the final decision with regard to what occurs. So I do begin my analysis of the case going to the statute that's been cited, but I want to reemphasize what it says. It's in 971.17 sub 4 sub D. It says the court without a jury shall hear the petition within 30 days after the report of the court appointed examiner is filed with the court. The court shall grant the petition unless it finds by clear and convincing evidence that the person would pose a significant risk of bodily harm to himself or herself, or of serious property damage if conditionally released. In making the determination, the court may consider without limitation, because of remuneration, the nature and circumstances of the crime, the person's mental history and present mental condition, where the person will live, how the person will support himself or herself, what arrangements are available to ensure that the person has access to and will make necessary medication, will take necessary medication, and what arrangements are possible for treatment beyond medication. So that is pretty well set forth also in the Randall case from 2011, which, as I indicated, is the most recent, really substantive case on the issue. I did some, as all good lawyers do, I shepherdized it. And it's been, the Randall case was referred to in 2 decisions, at least in earlier this year in 2024, but it's still good law. So now let's look at this case. First, the court looks at the what happened, the nature of the offenses. This is it's a brutal murder. Or it is a brutal attempted murder. And another aspect of the case is that everybody involved, the victim, the two assailants, are all 12 years old. They're all kids. But Ms. Geyser and Ms. Wire attempt to kill and wanted to kill the victim. The reports show that she was stabbed 19 times in the body, torso. And was basically left to bleed to death. It is fortunate that somebody came by and either saw her or heard her pleas and were able to get the authorities there, the fire department, the paramedics, to save her. Otherwise, she would have died. Now, there's a lot that can be said about that type of situation, but you think first of the effort to stab somebody 19 times. If you read the complaint and go through the history, she's on the ground, the knife is going in 19 times, and it's Ms. Geyser that's wielding the blade. But then she's not dead. But then they leave. And the only consequence of leaving under those conditions is, of course, that she'll bleed to death. If they thought, if they were able to think through that sophisticated maneuver, that she'd bleed to death and die. And the posited justification for the attempted murder was to appease Slender Man and become one of his disciples. Thus, the defendants, Ms. Geyser and Ms. Wire, then had packed up gear. They left and they started to walk up north to a national forest where Slender Man maintained his mansion, and then ultimately they're apprehended later on the freeway. But that's what happened. So we can't forget what happened, the brutality of it, the callousness of it, if you will. Keep in mind that the defendants are young, they're kids, but that's what they did. And that is a coloring, if you will, an umbrella over what the court has to look at in the case. Now we get to really analyze the reports, and I've read the reports. They came in early in preparation for the hearing. I read the reports and I've heard the doctors testify. What is significant, and we've talked about it, but we can't overshadow, we can't forget what those reports show and what the evidence presents. When we talked about the attempted murder, the rationale, if you will, for the attempted murder was Slender Man. That was the impetus for it. That's why it happened. That's how the case proceeded. That's how the initial diagnoses came forward. Those were the operative facts, the operative mental health facts, if you were, for the case. Now, the court is, I mentioned at the beginning of the hearing, ultimately, just to step back a minute, ultimately the court found the defendant guilty and the not guilty by reason of mental disease or defect based upon the statute. I committed her to the maximum that was available, and that was a 40-year commitment. Under the statute, a person can petition for a supervised release every 6 months. So this isn't, the only time limit is 6 months. So that's why it brings us here today. There were 2 other petitions filed. Ultimately, they didn't go forward. Now we're here on the 3rd petition. But that brings us, that's what we're here for today. Now back to this Slender Man situation. The diagnosis then was schizophrenia and some very sophisticated diagnosis with regard to both of the two defendants. That's how the case operated. And Ms. Geyser went through her commitment process with that being the diagnosis and what spurred the treatment on and what the treatment was based on. Now, back in, I think, 2022, beginning of 2023, that changed. And up to that point, Ms. Geyser was receiving psychotropic medications. Then she was alerted individuals that two things happened. One is she said that she faked the hallucinations and really the groundwork for the schizophrenia diagnosis, and she made it up. And she made it up because it all was, now that the shift occurred, or a shift occurred from the Slender Man situation to her father, and that her father had been sexually abusing her for a number of years, and that this is her way to get out of the family. She knew she wouldn't go back, but that's why she did a lot of these things. Now, we don't know whether that's true or whether the Slender Man situation is true necessarily. There's tremendous background, tremendous factual support, witness support, professional support that the Slender Man rationale for the murder, the attempted murder, was what was presented and was viewed as true and accurate. Ms. Geyser now reports that that's not true and accurate. Then we have the allegations with regard to the father. The father is now deceased. Comment as well, Ms. Geyser is essentially estranged from her mother. It's not clear whether there's been a rapprochement with the mother. It appears there may have been some effort at that. But that's still an issue that's outstanding. So now we have two new developments in the case that affects the diagnosis and really affects the risk assessment. And that is that Ms. Geyser changed what was the basis of the diagnosis and what was going on from schizophrenia, from Slender Man to non-schizophrenia type situation, that changed her medication. Her medication goes from psychotropic, psychotic medications. They took her off those medications. What's significant is, as I think Dr. Collins and Dr. Lundborn testified to, is that oftentimes when people are taken off the psychotropic medications, they at some point in time, they ultimately regress and go back into this old situation. That hasn't happened yet. That may be an indication, I think, as the doctors indicated, that in fact, the diagnosis was incorrect in the beginning. It may also be something that's going to reoccur in the future. That's an unknown, and we have to keep that in mind, that that's one of the unknown factors in the case. I mentioned the father's situation. Now, the father's situation comes into play as a rationale for what happened. So if you sort of play that out, what is the reason that she, along with Miss Hoyer, attempted to kill the
Oh? Uh-oh. Where's the judge? What? Guys, what just happened? What the hell just happened?
Mr. Brooks was coming up the driveway, and when I turned,
What just happened?
he kind of stopped. And I noticed that he wasn't
Well, let me see if I can.
wearing shoes.
Hope he's okay.
It was very, he was wearing just
That was bizarre.
blue jeans and a white t-shirt. And
I'm looking to see if there's a link somewhere else.
360 told me that he didn't have any weapons and that he needed a phone to call an Uber. And so I said, yeah, sure.
Um,
You know, I handed him the phone and I had suggested to him that my neighbor was
like it just got knocked right out.
so we continued to with the container and so I put the last one in and he handed me my phone and he turned the corner and
Well, holy crap.
just wanted to see if he,
I don't know what to say, guys.
the whole my neighbor was on the corner and he was gone.
I don't freaking know. Do you guys mind trying? If you guys find any link that may have restarted?
I'm not exactly sure. I think it was more or less all together.
That was bizarre. What the hell? But bye, OJ. He's all over the place here right now. 2 minutes ago. It's looking to me like it's just stopped. Maybe we should give it a couple minutes here. What do you think? Hmm? Yeah, what a time to drop out. Hope he didn't stroke out. Not trying to be rude, but that was weird. And I'm not finding it streamed. So it's not us. That's the big thing. It's not us. Hey, it's been not too bad as far as successes go. We got Dylan Rounds is back with his family. Rest in peace. OJ kicked the bucket. I think we're doing good. Diddy's going down, down, down. I don't know what to think, guys. Mexi, I think the guy just coughed and we lost our feed. It's gone. I can't find it. Maybe you can? But I'm looking everywhere and I'm just seeing, not seeing anything new. It just says 3 minutes ago now. How bizarre. What do you think of this, guys? Oh, yeah. And Apple River, Nikolai, convicted on all 4. 5 minutes now.
And did you see what that man did with the phone? I mean, actually, he told me that which I at the time thought was weird. That man then handed the phone back to you at some point? Yes. When you met with the police, did they ask to see your phone? Yes.
Okay, you guys. This is very weird. Well, I'm just going to turn this off, myself off for a minute. But I'm here looking. How bizarre, how bizarre. They're taking the judge to the hospital, maybe? Go help him with his yucky cough.
Exhibit 74 received permission of publishers granted. Objections overruled.
OJ's White Bronco, the real thing with JLR. It's about 40-second clip. Lordy, lordy. This is so bizarre, you guys. Good God, Chad's face is all over the place too. Yuck. Well, so it's going to be 10 minutes in this, just a few more minutes, guys. So I'm starting to think they might not be coming back. That's pretty odd. I don't think I've ever seen such a thing. How bizarre. I don't know what else to say about that. So I might be leaving it here. I'll come back. I'll be there in about 2 seconds and see if you guys have found anything. Any better luck than me. Damn. Okay, well, guys, I'm going to call it there because I'm not finding a damn thing. Did she get denied? How'd you find that out? No. I was behind, but I should have been able to continue with the stream. Oh my God, YouTube is being so bad. Oh my word. I don't know. Why was I behind it? That is not cool. Okay, then this is what I'm going to do. No, that's not the one I want.
I'm referring to a detective, Mandy M. Short, so that would be a woman.
What the hell? So I'm just going to find that part and we'll watch it. 'Cause that's no good. But why am I clicking on it and it's taking me to Koberger? That's not what I want. I want Slender Man.
Immediately after, it was the same.
I don't know. I don't like what they've been messing around with YouTube. I mean, look at that, just totally screwed up my stream. That is the very first time that's ever happened.
Red shirt, jeans, green shoes,
Okay.
The just an initial comment. The court asked Dr. Pope to be available from the beginnings in the event it was necessary that she testify. The issue of what happens at Winnebago for Ms. Geyser at this stage of her tenure there has been in the case. Everybody talked about it, that there's no place else to go, there's nothing else out there. I thought it was necessary that somebody from Winnebago be here to tell us what it really is, so we know what the status is. That's why I asked her to be present, and she repeated, didn't repeat, but she said what other doctors had said, that basically there isn't any place else from a remedial standpoint, not much else for Ms. Geyser to do. However, I forgot which doctor it was. It may have been Dr. Collins or Dr. Lundbone, did state that what happens in a situation if Ms. Geyser stays at Winnebago is that they reemphasize the therapy that she has and they work more diligently at it. So it's not totally an end of the line type situation. Parties should also keep in mind that it gets lost in the shuffle is that the court doesn't have to accept any professional opinion. It's clear that the court can listen to what takes place, but the court doesn't have to accept their final opinions. I look to the key case, not the key, well, it is a key case. There's a series of cases in Wisconsin involving Randall State versus Randall. Allen, Aiden, Randall. The most recent decision of the case is at 2011 WISAP 102. It's a 2011 decision, but Randall's been around since the mid-70s, 1975, 76. He murdered, the bottom line is he murdered 2 police officers in a really vicious way in the course of a robbery, and ultimately was committed and went through a number of petitions for review. And in, I think, at least in the 2011 case that's been cited, it was his 4th petition for review. There, all of the doctors testified, and the 3 doctors testified in favor of supervised release. The court denied it. So that emphasizes the point that the issue of experts testifying still doesn't change the court's view that the court makes the final decision with regard to what occurs. So I do begin my analysis of the case going to the statute that's been cited, but I want to reemphasize what it says. It's in 971.17 sub 4 sub D. It says the court without a jury shall hear the petition within 30 days after the report of the court appointed examiner is filed with the court. The court shall grant the petition unless it finds by clear and convincing evidence that the person would pose a significant risk of bodily harm to himself or herself, or of serious property damage if conditionally released. In making the determination, the court may consider without limitation, because of remuneration, the nature and circumstances of the crime, the person's mental history and present mental condition, where the person will live, how the person will support himself or herself, what arrangements are available to ensure that the person has access to and will make necessary medication, will take necessary medication, and what arrangements are possible for treatment beyond medication. So that's, and that is pretty well set forth also in the Randall case from 2011, which, as I indicated, is the most recent, really substantive case on the issue. I did some, as all good lawyers do, I shepherdized it. And it's been, the Randall case was referred to in 2 decisions, at least in earlier this year in 2024, but it's still good law. So now let's look at this case. First, the court looks at the what happened, the nature of the offenses, of the offense. This is it's a brutal murder. Or it is a brutal attempted murder. And another aspect of the case is that everybody involved, the victim, the 2 assailants, are all 12 years old. They're all kids. But Ms. Geyser and Ms. Wire attempt to kill and wanted to kill the victim. The reports show that she was stabbed 19 times in the body, torso. And was basically left to bleed to death. It is fortunate that somebody came by and either saw her or heard her pleas and were able to get the authorities there, the fire department, the paramedics, to save her. Otherwise, she would have died. Now, there's a lot that can be said about that type of situation, but you think first of the effort to stab somebody 19 times. If you read the complaint and go through the history, she's on the ground, the knife is going in 19 times, and it's Ms. Geyser that's wielding the blade. But then she's not dead. But then they leave. And the only consequence of leaving under those conditions is, of course, that she'll bleed to death. If they thought, if they were able to think through that sophisticated maneuver, that she'd bleed to death and die. And the posited justification for the attempted murder was to appease Slender Man and become one of his disciples. Thus, the defendants, Ms. Geyser and Ms. Wire, then had packed up gear. They left and they started to walk up north to a national forest where Slender Man maintained his mansion, and then ultimately they're apprehended later on the freeway. But that's what happened. So we can't forget what happened, the brutality of it, the callousness of it, if you will. Keep in mind that the defendants are young, they're kids, but that's what they did. And that is a coloring, if you will, an umbrella over what the court has to look at in the case. Now we get to really analyze the reports, and the I've read the reports. They came in early in preparation for the hearing. I read the reports and I've heard the doctors testify. What is significant, and we've talked about it, but we can't overshadow, we can't forget what those reports show and what the evidence presents. When we talked about the attempted murder, the rationale, if you will, for the attempted murder was Slender Man. That was the impetus for it. That's why it happened. That's how the case proceeded. That's how the initial diagnoses came forward. Those were the operative facts, if the operative mental health facts, if you were, for the case. Now, the court is, I mentioned at the beginning of the hearing, ultimately, just to step back a minute, ultimately the court found the defendant guilty and the not guilty of by reason of mental disease or defect based upon the statute. I committed her to the maximum that was available, and that was a 40-year commitment. Under the statute, a person can petition for a supervised release every 6 months. So this isn't the only time limit is 6 months. So that's why it brings us here today. There were 2 other petitions filed. Ultimately, they didn't go forward. Now we're here on the 3rd petition. But that brings us, that's what we're here for today. Now back to this Slender Man situation. The diagnosis then was schizophrenia and some very sophisticated diagnosis with regard to both of the 2 defendants. That's how the case operated. And Ms. Geyser went through her commitment process with that being the diagnosis and what spurred the treatment on and what the treatment was based on. Now, back in, I think, 2022, beginning of 2023, that changed. And up to that point, Ms. Geyser was receiving psychotropic medications. Then she was alerted individuals that 2 things happened. One is she said that she faked the hallucinations and really the groundwork for the schizophrenia diagnosis, and she made it up. And she made it up because it all was, now that the shift occurred, or a shift occurred from the Slender Man situation to her father, and that her father had been sexually abusing her for a number of years, and that this is her way to get out of the family. She knew she wouldn't go back, but that's why she did a lot of these things. Now, we don't know whether that's true or whether the Slender Man situation is true necessarily. There's tremendous background, tremendous factual support, witness support, professional support that the Slender Man rationale for the murder, the attempted murder, was what was presented and was viewed as true and accurate. Ms. Geyser now reports that that's not true and accurate. Then we have the allegations with regard to the father. The father is now deceased. Comment as well, Ms. Geyser is essentially estranged from her mother. It's not clear whether there's been a rapprochement with the mother. It appears there may have been some effort at that. But that's still an issue that's outstanding. So now we have 2 new developments in the case that affects the diagnosis and really affects the risk assessment. And that is that Ms. Geyser changed what was the basis of the diagnosis and what was going on from schizophrenia, from Slender Man to non-schizophrenia type situation, that changed her medication. Her medication goes from psychotropic, psychotic medications. They took her off those medications. What's significant is, as I think Dr. Collins and Dr. Lundborn testified to, is that oftentimes when people are taken off the psychotropic medications, they at some point in time, they ultimately regress and go back into this old situation. That hasn't happened yet. That may be an indication, I think, as the doctors indicated, that in fact, the diagnosis was incorrect in the beginning. It may also be something that's going to reoccur in the future. That's an unknown, and we have to keep that in mind, that that's one of the unknown factors in the case. I mentioned the father's situation. Now, the father's situation comes into play as a rationale for what happened. So if you sort of play that out, what is the reason that she, along with Miss Wire, attempted to kill the victim? Was it because of the alleged sexual assaults going on, the sexual abuse? Was it Slender Man? What was the reason? Nobody's really commented upon that during the course of this hearing. What has happened is that part of the focus of the case from the defense standpoint has changed. The emphasis or a lot of discussion centered on the father's sexual abuse of the child as a motivating circumstance, the catalyst for bringing about the crime that's incurred, the attempted murder of the victim. And throughout much of the hearing, the emphasis is what impact did the sexual abuse of the dad have on of Ms. Geyser, and how did that impact the case? The testimony of certainly of Dr. Lundborn, more than Dr. Collins, but Dr. Collins as well, is that the change in emphasis by Ms. Geyser as to what happened creates a credibility issue on her part as to what to believe, what not to believe. Is she a credible reporter in the future? Currently, is she a credible reporter currently as to what's really going on? What's been said oftentimes by the experts, and what we have to remember, is that in a case such as this, what impacts the perpetrator, what impacts someone in Ms. Geyser's position, is only known by the person. These are things that happen to them mentally. It's not something that somebody takes a picture of and say, isn't this what happened? You don't have that. You have to rely upon the reporter. So the credibility of the reporter is exceptionally important. Now, so we're faced with a situation, as has been testified to by I don't know if Dr. Robbins testified to it, but Dr. Lundborn did, and Dr. Collins, is that Ms. Geyser, under her current regimen, is successful. She's doing well at Winnebago. She's participating well, but she limits her participation. She doesn't go out on working as much as she could. She doesn't go out on as many efforts to get out in the public as she could. But the most they can do is what they've done. So it's almost to repeat, maybe with more emphasis, of what's happening. But it's certainly, that's where she is, and that's what Dr. Pope emphasized with regard to her testimony. The solution that's offered by Dr. Robbins, and to an extent by Dr. Lundborn, who mentions the halfway house as well in her report, is that she should be released to a halfway house and they do the rest of the work. The court reacts to that in a negative way. That means that the ultimate issue of risk assessment can't be made today. It has to be made after the torch is passed, if you will, to somebody else. That can't be the case. This court has to be able to make those assessments. Part of what the statute talks about is factors for the court to consider. the person's mental history and present mental condition. I've discussed that to a certain extent, and that is a big impact on the case. Where the person will live, we don't know. Yet where the person lives is significant as to where placement occurs, who the person lives with, how that mechanism will transpire. That we don't know. And we won't know for a period of time. It may be that it could be years before we know that. But we don't know because somebody else has to make that decision. I consider where the person lives on a petition for a conditional release to be extremely important. Where they live, who they live with, what the environment is significant. How the person will support himself or herself. That almost ties into where the residence is. We don't know. At this point, there's no plan out there. There's nothing been worked out. Now, of course, you see, well, in conditional release, that'll be worked out. But that's a factor the court has to know. Do they have somebody to help support them? Do they have a job they can go to? Do they have a plan for job training? All of that is really left open in this case. Another part of the statute refers to arrangements available to ensure that the person has access to and will take necessary medication, and of what arrangements are possible for treatment beyond medication. I'm satisfied that any conditional release plan, when it comes back, it'll have adequate provisions for that, for the medications and how that's continued. Now that's in the normal course, but the court knows today is that Ms. Geyser is under a treatment plan, medication plan, that she takes medications. They were disclosed in all of the reports. The court assumes to an extent that those continue unless modified during the course of the treatment plan. But so I assume that that's covered. I infer that that's covered. But those other issues that I talked about are not. So what we're faced with at this point is that Ms. Geyser is doing well in her program, that she needs socialization. She needs some outgoing, some further work in that regard. That's one aspect of it. The other aspect is her credibility is at issue. She's changed her position, and her credibility as a reporter is at issue. That the credibility of the reporter is critical to what assessments are made, how professionals, how mental health professionals make decisions. They're critical to how legal people make decisions. The credibility of the reporter is paramount, because that's the factual basis, that's the factual foundation for what occurs. When you put all of these issues together that I've talked about, all of these factual circumstances, we come back to risk. The dangerous risk is significant for the community. At this point, this court's satisfied that the credibility issue undermines Ms. Geyser's stay at the institution. That until that credibility issue is resolved, the risk is high. We have two different versions, in a way, as to why the attempted murders were committed. And, this isn't just an aspect where somebody drove a car into another car and drove off and left them sit there. This is a personal, if you will, a brutal attack on another person. This is hands-on, if you will. This is bloody, it's gory, but that kind of risk, that kind of dangerous conduct is what the risk is. Do we know if someone will repeat it? We don't know. But what this court's responsibility is to be sure that the risk is lessened. So as the statute says, the court shall grant the petition unless it finds by clear and convincing evidence that the person would pose a significant risk of bodily harm to herself or to others or serious property damage if conditionally released. This court is satisfied by evidence that's clear and convincing that Ms. Geyser does pose a significant risk of bodily harm to herself, to others.
So, guys, we're going to play nice, right? That's what this is about. This is the think tank. We all have our opinions and we all respect other people's. That's kind of the way it goes, right? So I'll give you my personal opinion. I believe that she should probably stay in the institution because she's not mentally strong enough to do this. And I also believe that she's schizophrenic and probably, she's in a mental health institution. She's got schizophrenia. And like a lot of people with schizophrenia, they want to fight the mental illness. They at times go, I don't need this medication, or I don't need this, or you're diagnosing me wrong. Something goes on different than how our minds work. So why I'm personally interested is I want to know how the human mind works. I mean, I've had stuff happen to me in my life that has made me question how somebody thinks the way they do. So having an interest on somebody's psychological is because she's a human. Yeah. We all have to have our own opinion. And we have to be respectful of other people's. No, that's right. We will never in a million years know how the human mind works. Not in our lifetime. I can agree with that, but that doesn't take the interest away. That doesn't make my curiosity go away. I'm curious about it. I mean, somebody else might be curious what it takes to grow, I don't know, a poinsettia, whatever. I could give two shits about that, but I am very interested in the human mind. And I'm also really willing to, okay, she was 12. She was 12. Hormones, schizophrenia, extremely bad childhood. But I'm not saying she should get out. I'm saying she's a person. And I'm interested on what makes her tick. But that doesn't make me doesn't mean you guys have to feel that way. But that doesn't mean I'm like going to go have supper or invite her to sleep over. But that doesn't, she seems, I'm not even going to get into it. Just play fair in chat. That's all I'm asking.
Or of serious property damage for the reasons that I've stated. Now, if she works hard, she continues to do what she's supposed to do, but that doesn't change this risk. Remember that the community is concerned with risk, dangerous risk. The community is concerned to a great extent as well with what happens to Ms. Geyser. But the primary concern in the balancing, and we talked about balancing earlier, in the Randall case, they talk about the balancing that goes on in the court's decision. The ultimate determination of dangerousness requires a careful balancing of society's interest in protection from harmful conduct against the equity of liberty and as well as autonomy. So that's the balance. But the balance is the public interest in staying away from harmful conduct. Under these circumstances, this court satisfied that the scales tip in favor of the public, and it tips that way by clear and convincing evidence. So in this matter, after hearing all of the credible evidence, which I'm satisfied was very well presented by both the state as well as by the defense, I'm satisfied that the petition should be denied. So ordered.
Thank
With
you.
that, I'll remand Ms. Geyser back to the Winnebago Mental Health Institute. So ordered.
Thank you.
Thank you, Judge.
Okay, court will be in recess.
So that is what we missed. Yeah, YouTube is totally being a mess right now. So yeah, she was denied, which is probably best. You know, I just had my little grr. But I have to remember, and I do remember, because we all have our own issues. We all have our own problems. She is in a mental institution and has been for 16 years. That's where she is. That's where she is. She's been there for, there you go. She's been in a institution. Is it 16 years? See? So I think it's very, very normal. 10 years ago it happens, Winnebago like 8. Okay. I had a way off. And how long has the other girl been in? 10 years on May 14th. Okay. They're not quite as bad as Jill, and she's getting care and being said, yeah. Okay. I don't know why I thought it was so much longer. Maybe it feels like it's been that much longer. But yeah, I don't want arguments, because we're all entitled to our own opinion. Okay, she's been out 2 years. Yeah. Thanks for joining us. That's awesome. Whew. She is, though, girlfriend. She is in a mental hospital. What did you call it? What was the name of it? Winnebago. She's in the Winnebago Mental Health Institute for 10 years, did you say? Let me go back. 10 years on May 31st. Yeah, I found it super, super interesting. I really did. I remember, obviously, I thought it was a lot long ago, but a lot longer ago. But I find it very interesting. Seriously, you see? Yeah, you see? No, she's not in prison. She is in an institution. Like I say, I'm not saying she should be out. That's not what I'm saying, even for 2 seconds. But I am saying, because I don't think she should be out. I don't agree with that. But I don't blame her for trying, right? How can you can't, it's her right to appeal these things. She's actually to do 40 to life, I believe. Well, there you go. Absolutely. But is doing right by a victim and families, but then is that the side of it? cases like this are always so complex in it's doing right by a victim and families. But then it's that side of it. Oh, agreed. Like, I am not saying she should get out because I don't think she should. But she does want to get out of the it sounds like she just wants out of that institution. And she needs, she needs to get mentally, she's got schizophrenia and isn't acknowledging it right now. So it's gonna be a difficult process for her, and I'm not even giving this as an excuse as to why this happened, but what I am saying is she's mentally ill. Oh, I couldn't imagine. I'd be like, they'd have me. Ugh. That's how they'd have me because otherwise I'd be. She's nowhere near getting out now. Yeah. And I mean, you know her and you say, don't let her out. So, right? And last year she was healthier. You see? And if they had have allowed that, she would have gotten to this point anyways, but without any help, right? Yeah. Yeah. And I feel horrible for the victim. This girl, oh my God, what she did. I mean, it's absolutely horrific. And I feel bad for her because she's got a lot to live with now. I'm just I keep putting a 12-year-old mentally impaired person. Was she diagnosed after the crime? What do you say? Oh, they did? They took off her ankle? Okay. Wow, that's interesting. Wow. Wow. But she was 12 also, right? Wasn't she 12 as well? I bet you they figured it out after. I'm thinking that's what I heard, but I'm not sure, Tracy. Where'd the guys go? Did they scare them away when I went in my little rant? I'm out of here. I'm sorry, I'm scrolling back. Lordy, lordy. Okay, I don't know. She diagnosed after the crime. Her family didn't think she was mentally ill. They thought she was quirky, according to the Be Aware, the Slender Man documentary. Oh, I think I've seen that. Yeah, Broadmoor. Ooh. Yeah. But think of a 12-year-old mind, right? And then think of a 12-year-old mind with schizophrenia, undiagnosed. And I'm not making excuses for her. I'm just kind of trying to see how this happened. Because there's no excuse. Don't get me wrong. I'm just really kind of, what? Yeah. Oh, okay. Oh, it's horrific. It's horrific. About an hour away for you? That's how I feel, Chopper. Exactly how I feel. I think there's more information that's needed before we can. Yeah, I'm going to keep in touch with the collector and see what we can learn. You know, if nothing else, it's maybe something with all the crime we do look at. Maybe something, a discussion on mental health would be interesting, right? Yeah. Lordy, lordy. That's what I'll ask to remember. She was a kid, but she did an adult crime. Medication was it refused before all this, but then the victim's family are number one. Absolutely, they are number one. Absolutely. That's very true. That's very true. Wow. Wow. Well, guys, I do believe it's time. It's that time again. So thank you guys very much for hanging out with me. I think that was really educational, and thank you very much to the collector. That was very informative. We learned a lot. Much appreciated, friend. And yeah, much love. I'll see you guys in the next one. Bye.